Brilliant Commercial Institute presenting shorthand, dictation, legal and journal passages for upcoming SSC, PSC, Rail, High Court, District Courts exam at the rate of 80, 100, 120, 140, 160 and 200 words per minute. For acquiring 120 and 160 speed in a very short time, you should follow these guidelines. Practice this dictated passage 4 times at a stretch in a day. Practice each outline before taking dictation thoroughly and transcribe and check your transcription from dictated passage which I dictated in this video. Let's start.
The Apex Court has taken note of a circular issued by the department clarifying the purpose and object of introducing Section 244 of the Act to replace Sections 214, 243 and 244 of the Act. By way of clarification, it has been stated that the said section is introduced for payment of interest by the department for delay in grant of refunds. The Apex Court observed, a general right exists in the state to refund any tax collected for its purpose, and a corresponding right exists to refund to individuals any sum paid by them as taxes which are found to have been wrongfully exacted or are believed to be, for any reason, inequitable. The statutory obligation to refund carried with it the right to interest also. This is true in the case of a cessee under the Act. On interpretation of the relevant provisions, it was observed that the rate of interest and entitlement to interest on excess tax would be determined by the statutory provisions of the Act. Interest payment is a statutory obligation and non-discretionary. Thereafter, in allowing the claim of the MS Tata Chemicals, Supra, it was observed that having established that the assessee was entitled to tax refund and the tax recovered is in excess of the tax paid, the amount realized in excess should carry interest. In fact, Section 244 provides the instances, the circumstances when right to claim refund arise and rates that an assessee can claim interest. Previously under Section 244 there was a general requirement to pay interest at 15% per annum on the amount of refund due from the date immediately following the expiry of the period of 3 months from the date of the order of the assessing officer. MS Tata Chemicals Limited having able to establish that they were entitled to interest on the refund under Section 244 their claims for interest at the statutory rate was allowed. However, in the instant case, there is no similar provision or any provision clarifying the amendment introduced in the year 2006. There was no such provision for payment of interest under the unamended provision. The amended provision prohibits payment of interest under the amended provision. However, our courts on the provision of unamended provision have taken a view that in view of Section 599 of the KMC Act, the provisions of the Interest Act would be applicable and interest would be payable on refundable excess amount. The appeal court, in affirming the view of the learned single judge, has also applied the general principle that payment of interest is in the nature of compensation for the use and retention of money collected unauthorizedly, and when such realization is illegal, there is a corresponding obligation on the KMC to refund such amount with interest for such wrongful retention and enjoyment of the said money in the aforesaid period. Ordinarily, a coordinate bench shall not differ or take a contrary view unless the decision of the earlier bench is per incuriam or sub silentio. The doctrine of precedent shall not be ordinarily departed unless there are good and strong reasons for doing so. It is important for smooth and systematic development of law and also for consistency. We feel that when a statute has been interpreted by learned single judge and to previous division benches of this court concerning the issues involved in this appeal, the doctrine of precedent needs to be followed. This is also another reason for which we allow the appeal and set aside the impugned order. In the instant case, initially the appellant asked for adjustment and thereafter asked for refund from the date of deposit with interest at the rate of 12% per annum till the payment is made. However, finally on 17th March 2004, the appellant demanded immediate refund of the excess sum of Rs 185,865 along with interest within a period of 15 days from the date of receipt of the said letter. The High Court exercises a plenary and extraordinary jurisdiction under Article 226 of the Constitution of India. Its power cannot be curtailed by any statute. Its power is as wide, expansive, and infinite as the horizon and as deep as an Atlantic. However, at the same time, the Constitutional Court over a period of time has imposed certain self-imposed restrictions. Its power is extraordinary, equitable, and discretionary. In the instant case, while we may find that there has been some delay in refunding the amount, but having regard to the explanation offered, it cannot be said that it was malified or intentional. KMC has offered its own justification, which cannot be said to be completely unmeritorious having regard to the view expressed by Justice Bhattacharjee. The understanding and the interpretation of the relevant provisions by KMC was subsequently held to be erroneous. It is true that the corporation for any default by an assessee charges interest at certain rate over and above the prime lending rate. However, it cannot be ignored that KMC is not a private profit-making organization and the amounts collected are to be utilized for performing and discharging certain statutory duties and obligations and for improving the civic amenities. KMC requires fund to meet the expenses for fulfilling various objects of the Act. Moreover, recovering such interest if there is a delay in payment of rates is in terms of the statutory provisions. However, this aspect of the matter has already been considered by Justice Kundu and thereafter by the co-ordinate bench in the first batch of writ petition filed by Larsen and Toubro Limited, Supra. While we do appreciate that by reason of the later judgment in Larsen and Toubro Limited, Supra, decided on 9th December 2011, the KMC ought to have been more